It was a big day at the Idaho Supreme Court. Justices finally hearing arguments on 3 Idaho abortion laws being challenged by Planned Parenthood. The court heard arguments for and against state abortion laws, including the so-called trigger ban that took effect in August. That law made abortion a felony in Idaho, except in cases of rape, incest reported to police, and in cases of saving a mother's life or when the mother's life is in danger. Today was about making arguments in court on all 3 of Idaho's recently enacted abortion laws. Planned Parenthood's attorneys argued for striking down the laws. Attorneys for the state legislature, which is the Attorney General's office, defended the laws, saying they're clean as is. The AG's office says the laws are about protecting preborn life and added the matter here should strictly be about interpreting law, not legislating abortion laws in court.
Petitioners come to this court with a policy dispute. They think abortion should be legal without thought to the lives of the preborn children who will be lost because they perceive abortion to offer benefits to women. The state has come down on the other side of the policy ledger. Now that Roe has been reversed, the state has exercised its power to protect the lives of preborn children, except when such a life would come at the expense of the woman or in the cases of rape or incest. This is a battle that is properly waged at the ballot box. It is not this court's place to adjudicate policy disputes.
The proceedings this morning went on for about 2.5 hours, with each side making their case for about an hour each. Both sides argued the 3 Idaho abortion laws on the basis of constitutionality, vagueness, and legal precedents in Idaho and the U.S.
Numerous provisions of the Constitution, standing alone and taken together, protect a woman's right to bodily integrity and autonomous decision-making related to procreation, including the right whether to terminate a pregnancy. As of the date of enactment, the Idaho Constitution recognized a right to be left alone, a right to privacy. Those are fundamental rights that I think the Constitution reserved to the people under Section 21. This court has had no difficulty concluding that those are fundamental rights.
And our Abby Davis joining us now. Abby, you talked to people on both sides of the political aisle about today's hearings. How do they feel it went?
That's right. Well, I talked to 2 state lawmakers, 1 Democrat and 1 Republican, and actually both of them are satisfied with the arguments made today.
I think it was very clearly expressed that the right to privacy is fundamental, and it's one that in the state of Idaho we have valued since statehood and before. And that right of privacy includes the right to choose when to procreate.
People are losing sight of the fact that a vast amount of Idahoans are not in favor of elective abortion as birth control. And so this trigger bill in particular was created to try to prevent that. But that's also why there are exceptions within the trigger bill. There are the exceptions for rape and incest, and there's the exception for the life of the mother, and that was very deliberate.
Critics of Idaho's abortion laws, namely Planned Parenthood, who filed lawsuits against the state, argue the 3 recently enacted abortion laws are not narrowly tailored and they're vague. Republican Representative Megan Blanksma says the legislature will most likely address those critiques during the legislative session in January.
I do think that we need to let the court play out and see what they have to say. Obviously, there have been some concerns, and we can review those, but understand that the legislature can't think of every possible scenario, and so they craft legislation to the best of their ability to address the larger concern. And that's what was done there, and if we find places that we do need to tweak, I'm sure that the members will be interested in reviewing what those possible tweaks could be.
In answer, Democratic Senator Melissa Wintrow says isn't good enough.
They've had plenty of time to get it right. It wasn't about getting it right ever. This was never about abortion, in fact. This is all about power and control of women's lives. And so if we think it's bad now, it's going to get worse, because we've already heard how they want to come after contraception, and that is all about controlling how a woman chooses to live her life.
There is no timeline for when justices will give a decision, but we're expecting that decision to come out in the next couple of weeks. And Morgan, to be clear, this case was in the state Supreme Court. Now, this is completely separate from the federal lawsuit that was filed by the Department of Justice. That is still ongoing, but once again, that was federal, and then this case today for arguments is in the state.
It's hard for people to keep up, so I'm glad you distinguished that. All right, Abby Davis, thank you so much.